very excited to welcome Jonathan Turley. Jonathan, thank you for taking time to speak with us.
Dr. Phil, it's a great honor to be with you. Thank you so much for inviting me.
I've been learning from you for a long time, and I mean that in all sincerity. You've had such a storied career. My God, you were the youngest chaired professor in GW law history, correct?
Yeah, it seems a long time ago, but that's correct.
I spent a lot of my career in the litigation arena in trial sciences, so I've been following you for a long, long time, as far back as 1990. I can't believe this is the first time we've ever spoken.
I know. I was thinking the very same thing this morning.
You've served as counsel in a variety of national security and terrorism cases. How did your career take a turn in that direction?
You know, Dr. Phil, I cut my teeth primarily as a criminal defense attorney. I went straight into teaching, but then I started to take cases on the side. I started to represent older prisoners in Louisiana, at Angola Prison Farm and other facilities. But I had also done a 2-year stint at the NSA with their general counsel's office as an intern. And I'd written a lot on surveillance. And so I've had a what's called a TSSCI clearance since the Reagan administration. And I sort of got pulled into it. The funny thing is, I absolutely hate national security cases. The problem is that you're in a small group that has handled these cases, which tend to be very complex. Judges tend, as do clients, to go to the same list of folks. But for a criminal defense attorney, it is common to feel that the deck is stacked against you. In many prosecution districts, the U.S. attorney and the local prosecutors have an over 90% conviction rate. There is that presumption of innocence, but the jury pretty much assumes there's a reason why your client's sitting behind that table. When it comes to national security, it's 100 times more difficult because the prosecutors can essentially control the evidence that you use at trial. So it's exhausting, quite frankly.
Well, it really is. I love what you just said, because I've spent so much time in the actual trial, and I always hear them say the burden of proof is on the prosecution or the plaintiff if it's a civil case. I found that to not be the case. I know that that's true legally. I know that's true constitutionally. But in practice, I always found that the jury believes that if we're not down here for what the prosecution is saying, you need to give me an alternative explanation for why we are here, because they're savvy enough to know there were 1,000 ways this case could have been disposed of before we got down here. And when they see the prosecution over there, and they know the court reporter by first name, and they say, hey, Doris, hey, John. They're familiar with the judge. They know the bailiffs. You got all of this mahogany wood, and the seal is up there, and the flags, and they seem like they're part of everything, and the defendant is a one-down interloper. And it just seems like the entire system is stacked against the defendant, and prosecutors just don't tend to bring cases they don't think they can win.
Yeah, and you're right about the relationship. I remember in Louisiana, where I clerked on the Fifth Circuit, one of the judges in a trial asked the defense, is the defense ready to present your case? And then turned to the prosecutors and said, are we ready to present our case? And so that relationship can get a little too close. I tell my students, this is an important principle of American law, the presumption of innocence, but don't you believe it when you go into that courtroom. The burden is on you. They believe your client is there for a reason. And so you've got to give them a clear narrative as to what really happened in this case. And you can do that. I think jurors are basically very fair people. I've always been impressed with juries, and sometimes I've learned from more experienced lawyers. I did a national security case involving a client people called Dr. Death. He was accused of giving vials of plague to Al Qaeda in Lubbock, Texas. It was completely ridiculous. But I remember I was trying to get out of Lubbock, Texas. My colleagues and I were filing for a venue change. And we had this old-time Lubbock lawyer who caught me. We lost that venue motion. And I was at a bar, rather unhappy with the whole thing. And this old grizzly Texas lawyer came and found me at the bar. And he said, can I tell you something? I know you're upset about losing that venue motion, but you're wrong. I think this is exactly the jury you want, because in this part of Texas, people don't assume the government's right. If you had gotten your wish and gone to Dallas, those people often do assume the government's right. And, he himself was absolutely right. And so I've learned a lot from lawyers like that over the years.
Yeah, I couldn't agree more. And I'm like you, I'm a fan of the jury system. I think they do get it right most of the time. It's been said that, the collective IQ of the jury is at least 1,200. And that's pretty damn impressive. And they get it right, but they get it right based on what's put in front of them, right? You see people go insane, like on the O.J. Simpson case, for example, or whatever. But the court of public opinion has a whole different set of data than those in the jury have. And the public thinks that they go back there and say guilty or innocent. That's not the case, is it? They have a whole set of jury instructions, questions that may be 6 or 7 elements that you have to answer. And if you answer those yes, then you go to page 19. If you answer no, you go to page 11. It's just not as simple as the court of public opinion. And they hear things that aren't admissible to the jury. And so the jury, I think, gets it right. But the caveat to that is based on what they hear. And I hear people say all the time, oh, maybe a lawyer's up there trying to get something in and they don't allow it. And I hear a lawyer say, well, we didn't get that in, but the jury knows we had something really powerful and they kept it out. No, they don't. I've found jurors decide cases on what they see and hear, not on what they don't see and hear. And 6 weeks later, they forget all about that. They only know what they see and hear. And that's been my experience. I'm curious what your thoughts are.
No, it's true. Jurors are incredibly conscientious. The problem is that it's a sort of garbage in, garbage out. If the judges blow it, then you're going to get a bad decision, because often the jurors do find it frustrating. Sometimes they'll ask for information, the judge will decline to give it to them. And sometimes the instructions are wrong. A good example of that is the Trump trial in Manhattan. I objected to people who were attacking the jury in that case. I know a lot of people felt strongly on both sides. But that trial, I think, was undermined by one of the worst jury instructions I've ever seen, where Judge Merchan told the jury they didn't have to agree on what happened. That is, they said that, this whole principle of the case was that Trump committed these violations to hide a federal crime. But Merchan said, you don't have to agree on what that crime was. Well, they went, if I was given an instruction like that, of course they're going to convict, because it would mean that they could just break into groups of 3 as to what really happened in the case.
That was one of those situations where I thought, this can't be right. And so I sought out what you had to say about it, as I often do. And it seemed to me like you have to have a unanimous verdict. And how can that be if you don't have to agree on what the transgression was, what law was broken, what he did? It seemed to me if that had gone up the chain and gone to the appellate court or Supreme Court, is there any way that they could have held that on appeal?
Well, it still may. It can still be reviewed. It's going to be a slow process. But in my view, that order itself doomed the trial. I think it's unconstitutional. I thought the entire case was really pathetically unfounded. I mean, because basically they had a dead misdemeanor in New York that they zapped back to life as a felony by claiming that the statute of limitations doesn't mean anything because he was trying to avoid another crime. Well, that other crime was a federal crime. This is a state court, and the federal government didn't charge on that crime. So even my counterparts on CNN said, look, this is a really weak case. But the atmosphere inside the courtroom is very different from the atmosphere outside. The reason the subtitle of my book is Free Speech in an Age of Rage. Rage is all around us. And as I discuss in the book, rage is an odd thing. It's addictive, it's contagious, But the one thing that people won't admit is that they like it. It allows you to do things and say things you wouldn't ordinarily do or say. And both parties have this rage addiction. When I came out of the courtroom in Manhattan after the verdict, there were people dancing in the streets.
Right.
And even though I'd just written a book partially on rage, I stood there just shocked, to see it. And you do see the addictive quality of it. And, the fact is, it's during periods of rage that we lose civil liberties. That is the most dangerous period for free speech, is that in each of the periods, my book talks about the periods and personalities that helped influence our understanding of free speech. But we're not as good as our advertising. We have arrested people by the thousands, communists, socialists, unionists, feminists. It occurs when we're really angry or we're really afraid. And we then turn on our neighbors. We turn on free speech.